sonze bica bivamo ngira ntibaratangura erega nibo bavyakiriza umwana wiwe ngo yavuze umuhungu wiwe ngo nzogenzura abakobwa ngo gushika nanje ndose ngo umuntu avuze induru nka mama.
Good morning, distinguished delegation, colleagues, observers, friends. This is the 3099th meeting of the committee, so we're going to have a really good round number this afternoon. You'll recall that the distinguished delegation of Sri Lanka that's been presenting its fifth periodic report was coming towards the end but hadn't concluded its responses to colleagues' questions following up to the state party's replies to the list of issues. So what I propose is that the delegation continue with its responses, and then in function of the amount of time available, I'll indicate whether or not we're going to fold in follow-up questions from colleagues into the second round of questions on issues 14 to 26. So with that, I return the floor to Ambassador Ariasina to orchestrate the rest of the responses to colleagues' questions. You have the floor, sir.
Thank you, Mr. Chairman and Commissioners and ladies and gentlemen. In the first round, we have left behind still 4A, 6, 9, 11, 12, and 13. So let's try to get through those as fast as we can. Let me first give the floor to Mr. Rajiv Gunatilaka, Senior State Counsel, to take on question number 6.
Thank you, Ambassador. Good morning, Mr. Chair, members of the committee. I will be providing some responses to the issues that were raised on the item number 6 by Mr. Flinterman. We would like to state that Sri Lanka did, in fact, in terms of Act number 22 of 1995, as an amendment was made to section 363A of the Penal Code, in which a man, according to the amendment, is said to commit rape who has sexual intercourse with a woman without her consent, even where such woman is his wife, and she is judicially separated from that man. Mr. Flinterman raised the question whether it would be possible to criminalize rape even where there is no judicial separation. And our response to that is that although the act of sexual intercourse without the consent of the wife is by itself not a crime in Sri Lanka, if such an act involves violence and there is evidence of that violence, then the man can be charged under the Penal Code, and you can also get some relief in terms of the Domestic Violence Prevention Act. So I think that would be a suitable response to Mr. Flinterman's concerns on that issue. As to the question of sensitivity and sensitization of the attitude of officers as well as the public, we wish to state that the government has taken steps to prevent violence at the workplace by appointing general focal points in line ministries and setting up sexual harassment committees to provide awareness to the staff, as well as to motivate them to report such cases and to carry out investigations. So there is a process of sensitization in the workplaces that is going on. We would also like to state that a shelter for victims of domestic violence was established in 2012 in collaboration with the International Organization for Migration. Domestic violence is a subject which is widely taken up in awareness programs conducted by the Women's Bureau. I would like to emphasize that this Bureau has conducted case conferences on domestic violence in places such as hospital gender desks and together with district secretariats. These are the administrative units that function in all parts of the country, and this includes district secretariats in the north and east. I believe, Mr. Chairman, that we have sufficiently addressed those concerns that were raised by Mr. Flinterman. Thank you very much.
Thank you very much. Let me, yes, on 4B, let me invite the additional Senior Additional Solicitor General to make some comments.
Thank you, Ambassador. There was this question raised by the learned member from Netherlands regarding the composition of the committee established to look into the reforms to Muslim marriages ordinance. I can give you the information now, Honourable Member. This is headed by Justice Salim Massouf, Process Counsel, Judge of the Supreme Court, is the chairman. And then in addition, we have Justice Salam, Judge of the Court of Appeal, Mr. Shibli Aziz, President's Counsel, former Attorney General, Mr. Faiz Mustafa, President's Counsel, former Deputy Director of Public Prosecutions, Professor Sharia Shangavel, Mrs., Executive Director for Center for Human Rights Studies, Judge Mohammed Maki, District Judge, now Justice of the Appeal of the Civil Appellate High Court, Mr. Jabbar, former Chairman of the Board of Causes, Dr. N.A.M. Shukri, Director, Jamaya Nalimaya, as Sheikh Mohammed Magdoon Ahmad Mubarak, former President, Jamaitul Ulama, as Sheikh Mohammed Ibrahim Mohammed Rizvi Mafim, President of Jamaitul Ulama, Mrs. Jasima Ismail, Member of the National Committee on Women and Human Rights Commission, Mr. Asmara Abdeen, Attorney at Law, Mrs. Safana Gulbegum, Attorney at Law, and members of the Muslim Women's Research and Action Forum, Mrs. Fasle Shahabdeen, Attorney at Law, then Mrs. Dilhara Amar Singh, Additional Secretary, Mr. A.K.D.D. Arandara, Assistant Secretary to Ministry. Now, so that this would show that there are 3 lady members, female members in this committee. Thank you.
Thank you very much. May I invite to respond to question 9, the Additional Secretary, Ministry of Law and Order. May I give the floor to him, please?
Thank you. Mr. Chairman, on behalf of the government and delegation, let me respond to part of the issues raised under question number 9. The government of Sri Lanka rejects the assertion that there are consistent and well-documented reports that unlawful use of force and violation of the right to life by state agents or by paramilitary groups directly under the control of armed forces, including extrajudicial killings, suspicious deaths in custody, and enforced disappearances remain widespread and unpunished. Whenever credible evidence is available, steps have been taken to prosecute police officers who are responsible for arbitrary killings. A few examples on prosecuting police officers are as follows. A sub-inspector who was the officer in charge of crimes of a police station was indicted along with another person for the killing of a witness in a pending case. The High Court trial is in progress and is presently adjourned for the conclusion of the defense case. Second one, in relation to the shooting incident at Katnayak in May 2011, steps have been taken to institute non-summary proceedings before the magistrate of Negambu against 2 police officers on charges of murder and attempted murder. The inquiry is in progress. Next, 4 police officers, including an inspector who was in charge of the police station, were convicted by a trial at bar. In August 2011, for conspiracy, abduction, and murder of 2 individuals, a 5-judge bench of the Supreme Court on 2nd April 2014 dismissed the appeal of all 4 accused and affirmed the conviction and the sentence pronounced by the trial at bar. Next, the trial of a Deputy Inspector General of Police, who is indicted along with several others on charges of conspiracy, abduction, and murder before a trial at bar, is presently in progress before the High Court of Colombo. It should be noted that Sri Lanka has a well-established criminal justice system to investigate and prosecute perpetrators. Existing provisions in the Penal Code sections 350 to 360 adequately covers any situation of kidnapping, abduction, or disappearance. The state has used the provisions of the Penal Code to prosecute those responsible for causing disappearances of persons. In a recently decided case of C. Earl Fernando and H.P. Premaratna versus the Attorney General, in the Court of Appeal concerning a disappeared person, the court confirmed the conviction and the sentence given by the High Court of Gampaha against the police officer who was in charge of police station. The court held inter alia that, I quote, "This court is of the view that failures to comply with the legal provisions that complete a legal act of an authorized officer make such an act illegal with the consequent liabilities. I, therefore, hold taking away Upal from his workplace by the first accused appellant was none other than abduction with intent to cause him to be secretly and wrongfully confined." With this conclusion, this court upholds the conviction of the first accused appellant, unquote. Further, Sri Lanka Police has issued clear instructions by a Crime Circular number 22/2011 on the procedure to be followed by the respective police officers. Furthermore, the rules with regard to rights of persons in custody and the duties of the police have been clearly and precisely specified in the Departmental Order number 820. Thank you.
Mr. K.D.S. Ruwan Chandra, Additional Secretary, Ministry of Law and Order. May I now invite Deputy Solicitor General Nerin Pulle, who will take up the section question area number 11. No, ACF and Trinco.
Thank you, Ambassador. Mr. Chairman.
Mike.
Mike.
Members of the committee, there has been certain concerns raised in forums with regard to 2 particular issues, 2 particular cases, which I think warrant some response. And Ambassador refers to this arises under question issue number 11, which deals with matters of accountability. But I would just briefly summarize certain matters that have taken place with regard to 2 particular cases in issue. There were 2 cases which I would like to draw your attention to. One is with regard to the killing of, regarding case related to the killing of 5 students in Trincomalee in January 2006. Now, in that context, might I just briefly outline some of the matters that have taken place in the court proceedings, because this is a case that has been pursued and followed. The case relates to the massacre of 5 students in Trincomalee on 2nd January 2006. two other students survived the incident with injuries. At present, the non-summary proceedings have commenced against 13 accused who are STF personnel operating in the area at that time. The non-summary was first taken up for inquiry on 5th August 2013. The accused were represented by lawyers. Now the non-summary commenced on the special procedure under the Criminal Procedure Special Provisions Act number 2 of 2013 and in the Magistrates Court of Trincomalee. And on that day, although the prosecution had moved for summons on the first 18 witnesses on the charge sheet, only witnesses number 13, 14, 15, 16 and 18 were present. So basically only 5 witnesses were present, though the prosecution moved for summons. And presently the prosecution has called witnesses, several other witnesses, and out of that 25 witnesses concluded so far. 12 witnesses have given affidavits for the record. These witnesses include relatives of the deceased, the JMO who did the postmortems and the medical legal reports, security forces personnel who were near the scene, as well as the police witnesses who were in the party which first came to the scene on the hearing of the alleged shooting. These witnesses were cross-examined by the defense counsel where necessary, and the evidence was concluded. The police officers who investigated the above incident have also given evidence. Now, for the record, I will try to reduce my speed on this. Now, the summons report of the CID was filed in court and indicated that witnesses number, total number of 8 witnesses were abroad. And these witnesses included the 2 injured boys who survived the incident, who have since left Sri Lanka. Now, CID wanted further time to locate the present foreign address of these witnesses. The prosecution has moved for summons on these 3 witnesses by email, as the CID summons report disclosed an email address given as vvy.yoganathan@yahoo.com. Now that was an address, and the registrar of the Trincomalee Magistrate Court was directed to issue an email notice about the further date of inquiry. However, there was no response to the mail that was successfully delivered. At present, the prosecution is the process of proceeding with this matter, and on the last occasion when this matter was taken up for inquiry on the 17th of September, there were further proceedings for adjourned for the 21st of January 2015 on the basis that then there is a need to trace the whereabouts of these witnesses through the mechanisms of the Justice Ministry and the External Affairs Ministry. So that is the current position of this case, which is being pursued, and this is being handled by a very senior officer of the Attorney General's Department, and under the guidance and direct supervision of the other senior officers of the department. Now, with regard to the matters raised with, I would also at this point think it's appropriate to refer to the ACF issue. Now, with regard to the ACF matter, known as which happened in the Muttur area, the following instructions by the Attorney General. Action has been taken to identify and record statements from witnesses material to this incident. The police have also obtained clarifications on the issue of the exact number of dead bodies from the Additional Director of the Consortium of Humanitarian Agencies, and the report he prepared with regard to his visit to Muttur on the 6th of August 2006. Meetings have also been held. Now I must stress on this point because this is of significant importance. I think Ambassador has made this point even in the council sessions and made it very clear that the Attorney General, meetings have been held by the Attorney General with the French embassy officials, during which the progress of the investigation was discussed. And it must be noted that the Attorney General has expressed willingness, I stress that point, that the Attorney General has expressed willingness to accept the assistance of the embassy in facilitating and obtaining the statements from witnesses known to them and living in France, whether in France or in Sri Lanka. So that position of the Attorney General has been made very clear, and I believe that process is ongoing, and the Attorney General is also keeping note of those developments. So with regard to those 2 particular aspects, the Muttur incident and the Trincomalee incident. The progress is ongoing, and the Attorney General is with very senior officials of the Attorney General's department handling these matters. These are receiving very close attention of the Attorney General. So I think that those are the developments that I wish to report to the committee at this point of time. Thank you.
Let me also take part of that question relating to this issue, particularly the Army Court of Inquiry, about which some questions were raised yesterday, as well as the second part of it, Channel 4. It's also important, I think, in this context to remind you that these cases which have been gone into are being pursued on the basis of the recommendations of the Lessons Learned and Reconciliation Commission's identification of specific cases which they felt needed further probing. And it is in response to that the National Plan of Action has taken these on, and these have been various institutions have been asked to look at these as the Attorney General's office on the one hand and the Army Court of Inquiry on the other. Now, with respect to the Army Court of Inquiry, it is well recognized that in matters pertaining to internal military matters, including matters of military discipline, especially with regards to violation of IHL, military courts have the jurisdiction, and the legality of these military courts have been recognized by many international instruments on IHL, including the Geneva Conventions and the Hague Conventions. This practice is followed almost universally regarding military matters. Therefore, by virtues of the powers vested in the Commander of the Army by the Army Act and regulations made thereunder, he appointed a Court of Inquiry to inquire into the observations made, as I said, by the LLRC in its report on alleged civilian casualties during the final phase of the humanitarian operation and probe as regards Channel 4 video footage, irrespective of its authenticity or otherwise. The 5 members of the Commission of Inquiry was appointed on 2nd January 2012 by virtue of the powers vested in the Army Commander by Regulation 4 of the Court of Inquiry Regulations, read with Regulation 2 of the Army Disciplinary Regulations, and is headed by a Major General. The Court of Inquiry is an initial fact-finding inquiry akin to a magisterial inquiry where there are no suspects, but on certain matters affecting the reputation of military personnel, they are allowed to be present and to cross-examine the witnesses. If there is a prima facie case disclosed against any person from the evidence led before the Court of Inquiry, a general court-martial is convened to try the alleged offences. A general court-martial has the jurisdiction that is similar to a high court trial at bar and can award any sentence according to law. Findings of such court-martials are subject to review by the civil courts, the Court of Appeal. Further, the fact that this exercise was undertaken approximately 7 months before the National Plan of Action for the implementation of the LLR's recommendations was launched demonstrates the GOSL's commitment to address issues of accountability. The first part of the COI, alleged civilian casualties during the final phase of the humanitarian operation, has been concluded, and the Commission of Inquiry report was handed over to the Army Commander on 15th February 2013. Although the COI report cannot be made public, a summary of the findings is available online, which include inter alia the following. A. The court examined senior field commanders and infantry, armor, artillery, intelligence, civil affairs, and medical officers who had participated in the humanitarian operation. From the evidence presented, the Court of Inquiry concluded that LTT terrorists had acted with impunity by committing various unlawful acts, inter alia, using of civilians as human shields, placing of artillery and other heavy weapons amid civilian concentrations, and illegal conscription of civilians, including children and old people, for combat purposes, thus exposing them to danger and transforming their status to that of combatants. Evidence before the court has also conclusively established that the humanitarian operation was conducted strictly in accordance with the civilian casualty directive made by His Excellency the President Mahinda Rajapaksa, and commanders at all times obeyed and sent directives, and even where the LTT terrorists had fired from no-fire zones, commanders refrained from firing at such no-fire zones. It has also been revealed that as an additional measure of safety, artillery commanders had added 500 meters to the boundaries of the no-fire zones given by the higher headquarters. During the court of inquiry, it transpired that LTT terrorists had located artillery and other heavy weapons amid civilian concentrations, and from such locations they repeatedly fired at the Sri Lankan army positions. However, despite heavy bombardments by LTT terrorists, Sri Lankan army troops had refrained from firing heavy weapons, and this self-imposed moratorium had caused heavy casualties to the Sri Lankan army troops. Evidence revealed that at all stages of the humanitarian operation, the Sri Lankan army behaved as a well-disciplined military force, observing the international humanitarian law and the law of war, and they took all precautions to avoid civilian casualties, and all those who came under the control of the Sri Lankan army, including surrendered captured LTT cadres, were treated humanely, observing international IHL. On the contrary, shocking details of war crimes committed by LTT terrorists, such as using the civilians as human shields, summary execution of civilians who attempted to escape to army lines, forced conscription of children for combat purposes, etc., were revealed at the inquiry. The court noted that the international community had failed in their duty to stop the war crimes committed by the LTTE. From the testimony presented, the COI concluded that the instances of shellings referred to in the LLRC report were not caused by the Sri Lankan army, and civilian casualties might have occurred due to unlawful acts by the LTT. These acts, including firing at civilians fleeing to the safety of the army-held areas, dropping of artillery rounds fired by ill-trained LTT gunners onto civilian concentrations, employment of substandard artillery rounds obtained from illegal sources by the LTT, forced conscription of civilians, including children and old people, by LTT for combat purposes, thus exposing them to danger. It may be observed that collateral damage may be caused in any war, even those conducted under the auspices of the UN. What is significant, may I add, is that at the end of that conflict, nearly 300,000 innocent civilians moved back through spores created in the defenses of the LTT to the government-controlled areas at the time, and were brought into the IDP centers and were looked after. So I think that makes very clear that the Army Court of Inquiry has not just done its job, but they have made public a summary. Now, as far as the court does not blame any army member, and if any new evidence is presented by any person giving precise information on civilian casualties, it is committed that such instances will be investigated further by giving such persons the opportunity to present their evidence. Now, on the Channel 4 footage, which is still ongoing, that part of the inquiry is not completed. Notwithstanding the authenticity of the Channel 4 footage and acting on recommendations of the LLRC, the Commission of Inquiry is currently investigating the second part of their mandate to examine the Channel 4 allegations. The failure on the part of the parties alleging excessors by the Sri Lankan military to provide the original footage, despite requests for provision of the same, along with further information on the possible locations, dates and other relevant information, has impeded the progress of the investigation. May I add that on the Channel 4 footage, an invitation was also extended for the producers to present their material before the LLRC when it was meeting once again, which which was not responded to. Despite these difficulties faced, the Court of Inquiry continues to endeavour to ascertain the veracity of the incidents. It is unfortunate that the Sri Lankan military continues to be unfairly accused on this matter on the baseless and uncorroborated evidence. As to why, as a member of the committee asked, the report is not released, may I say that the simple reason is that it is a classified document and hence not a public document. Even courts recognize this and as such does not insist on the production of such documents. These documents within the military also can be accessed only by authorized persons and is meant for internal use only. However, this is different to proceedings of a court-martial which can be called upon by the civil courts for scrutiny. That's the answer to the section 11 where there were specific cases which were mentioned. If I may now move to question number 12, where there was a question about the Secretary General's panel report and what we are doing about it. Secretary General panel of experts report. I'm glad that the committee member who mentioned it called it the Darusman report, because I think that is exactly what it is. It was a panel which was set up to advise the Secretary General and it did not have any intergovernmental mandate, and therefore it was a report which had no status whatsoever in international terms. It is for that reason that it is a document which has no number and has not been circulated within the UN system. So I think it is unfortunate that the government of Sri Lanka is asked to respond or to act upon a report which is so determined. And it is also very important that the commissioners themselves made very clear that they did not have a fact-finding or investigative mandate. They made it clear that the assertions set out there remain unsubstantiated and require a higher standard of proof. And it is for the above reasons that the government of Sri Lanka does not extend any credence or legitimacy to the POE report and protests any references made to it. It may be further noted that the POE, though invited by the LLRC to make presentation to the Commission, chose not to present themselves to the LLRC before the Commission for reasons which are best known to them. Now, alternately, what the government of Sri Lanka said it will do, and it has done, is to appoint, on the recommendations of the LLRC, we appointed a commission of inquiry to investigate into missing persons in the northern and eastern provinces, based on the recommendation of it on 15th August 2013. The scope of this mandate was extended on 15th August 2014, among others, to investigate and report into facts and circumstances that led to the loss of civilian life during the internal armed conflict that ended on 19th May. The original mandate was to investigate into disappearances. The extension was to look at civilian loss of life and whether persons, groups, or institutions directly or indirectly bears responsibility for violations of international humanitarian law or international human rights law. The Commission has held regular meetings with the ICRC and the UNDP and have obtained their views and experiences gained in other parts of the world, particularly on matters relating to missing persons at the end of the conflict. The Commission the following international experts have also been appointed to serve as an advisory council to the Commission on the request of the chairman of the Commission. These commissioners are the Right Honourable Sir Desmond de Silva, QC, Chairman, Sir Geoffrey Nice, QC, Professor David Crane, Mr. Avadash Kausal, and Mr. Amir Bilal Sufi. You will appreciate that it is a fundamental principle of international law that national remedies have to be exhausted before resorting to international mechanisms, and in this context it is pertinent to note that national mechanisms for accountability are underway and have not been exhausted. Therefore, while Sri Lanka remains open to international assistance to its domestic mechanism as and when necessary, it rejects any undue and unwarranted interference that seeks to impede its ongoing reconciliation process. Mr. Chairman, if I may mention it, this position was taken by the government of Sri Lanka when the High Commissioner's oral update came up for discussion on the 25th of September it was very recently. And in addition to Sri Lanka's arguments relating to it, which I don't want to go into, but it is very much in the record of the HRC, there was a group of countries, a like-minded group of countries comprising 22 countries, who very vehemently stated that the intrusive mandate given to the OHCHR by Resolution 25-1 to carry out investigations on Sri Lanka is unwarranted. It was noted that the OHCHR's efforts should contribute to a state's own efforts in promotion and protection of human rights as stipulated in the UNGA Resolution 48/141, UNGA Resolution 60/251, UNGA Resolution 65/281, and on the IB package.
If this continues much longer,
I'm finishing it. I'm finishing it, yes. And so therefore, my point is that we do not recognize the POE. We are engaging in a domestic investigation, and the fact that domestic remedies must be exhausted before international remedies has been acknowledged by many countries in the Human Rights Council. Thank you.
Thank you, Ambassador. It's now clear that colleagues' follow-up questions will have to be wrapped into questioning in relation to issues 14 to 26. So in a moment, I'm going to go to that next stage. But just so that the discussion proceeds appropriately, let me be very clear about some things. One is that members of this committee are experts, and they're free to look at any sources they consider pertinent to the ascertainment of the facts. And their status vis-à-vis the government of Sri Lanka, vis-à-vis intergovernmental organizations, or anything else is neither here nor there. And it is simply not good use of this committee's time to discuss the authenticity of reports rather than what committee members are concerned of, which is the factual information in respect of which responses are being sought. The second is just to remind members of your delegation, sir, that committee members serve in their individual capacities. Their nationalities are neither here nor there. They can either be referred to by their names or by, as the member who referred to a question under issue this, that, or the other. But please, no national identifications, as though somehow committee members are reflecting their country's policies. This is something the committee has generally been very neuralgic about, and will continue to do so. Thank you. I hear the apology, and it's accepted fulsomely. So with that, we now go to the second round of the list of issues, and I already have a provisional list, but obviously there'll be some follow-up questions as well. The first speaker on my list is Mr. Newman. Mr. Newman, you have the floor.
Thank you, Mr. Chair. And I'd like to thank the distinguished delegation for its response to my questions yesterday. Today I'm responsible for 4 issues, numbers 14 through 17, and I will try to be brief so that the distinguished delegation will have the opportunity to provide the information that was requested but not provided in the reply to the list of issues. Issue number 14 relates to torture and other ill treatment. As the distinguished delegation knows, there continue to be reports of ill treatment in police and military custody, not only in the North and East, but also in cases of ordinary police work in other parts of the country. The reply to the list of issues deals only with the question of the legal definition of torture. I am mostly content to accept the state party's commitment that the term pain in its statute also includes suffering. And I would like to ask for confirmation that as a result, the definition of torture also includes rape. There are reports of medical examinations of former detainees which document injuries resulting from beatings and burnings and from sexual assaults. Issue 14 asked for data on investigations, prosecutions, convictions, and punishments, but no data were given in the replies, which strengthens the appearance of the allegations that impunity prevails and that the police and the military are not being inhibited from violating the laws against torture during interrogation. The Committee Against Torture expressed concerns about the prevailing impunity, the absence of investigations, and the absence of an independent investigative mechanism for cases of torture and ill treatment in its concluding observations in 2011. If there is information demonstrating that the situation has improved since that time, I would ask the distinguished delegation, please, to provide such information. I move next to issue 15. Issue 15 asked about measures to deal with arbitrary and unlawful detention. The reply to the list of issues in that regard speaks only about a draft bill. That worries me for two reasons. First, because there is no guarantee that a bill will become law. And second, because the basic concern was that police do not comply with the laws that already exist, and that they do not suffer sanctions for violating them. It appears to remain true that even as a matter of law, criminal suspects lack basic safeguards against ill treatment in custody, such as access to counsel from the moment of arrest, access to an outside medical examination, the presence of counsel during interrogation, and the right to confer privately with counsel. There is no central register for all persons who are arrested, and there are numerous reports of persons being held in unauthorized places of detention. Again, it appears from the silence in the reply to the question that victims of arbitrary arrest do not receive remedies and that those who carry out arbitrary arrests are not sanctioned. This committee is aware from individual communications and from other sources that sometimes victims who complain about arrest or ill treatment have received threats from the police and pressure to withdraw their complaints. In that connection, am I correct in believing that the bill on the victims of crime and witness protection, which is discussed in the state party's report, was finally introduced in Parliament last month? Has it been enacted yet? What will this bill, if enacted, do to protect victims from retaliation for reporting violations of their rights? I turn next to issue number 16, which involves prison conditions, including overcrowding. I'm glad that the distinguished delegation acknowledges this as a problem. The Special Rapporteur on Torture in 2010 reported that prisons operated at more than 3 times their capacity, and that legal rules on separating detainees on remand from convicted prisoners and separating juveniles from adults were often not respected in practice. The replies to the list of issues mentions the building of new prisons as a way of dealing with this problem of overcrowding. That would have some benefits, but it is slow and expensive. The summary that was given yesterday of the replies to the list of issues contained some new elements that were not in the reply, mentioning community-based corrections instead of imprisonment for certain less serious offenses. That may be a useful method of preventing prison overcrowding, and I would welcome more detail about the types of cases in which that technique is used. More fundamentally, it appears that there is excessive use of pretrial detention and extremely long delays before trial in the very inefficient court system. According to one report, more than 1/3 of the detainees in prisons have not yet been convicted. Other reports place that percentage higher. Article 9, paragraph 3 of the Covenant requires state parties to consider alternatives to pretrial detention and to review the necessity and proportionality of pretrial detention as the delays in bringing them to trial continue. What is the state party doing to comply with that requirement, which would also have the side effect of reducing prison overcrowding? The replies do not address the creation of a truly independent system for regular monitoring of prisons with sufficient funding to inspect often enough to have real effect. They also did not discuss any measures to improve the slow pace of judicial proceedings in criminal cases, which is itself a problem under Article 9, paragraph 3 of the Covenant and Article 14, paragraph 3 of the Covenant. If the distinguished delegation has any information to provide on those subjects, I would be grateful for it. Finally, I turn to issue number 17. Issue number 17 concerns the independence of the judiciary. There have long been concerns about judicial independence, including about the intimidation of judges by threats and even by physical attacks. For example, in 2012, there are reports that the president of the Court of Appeal and 2 other judges were threatened, and that the secretary of the Judicial Service Commission was assaulted and had to be hospitalized. When law enforcement officials are notified, the investigations fail to produce results. The 18th Constitutional Amendment has put the appointment of the Supreme Court, the Courts of Appeals, and the Judicial Service Commission entirely in the hands of the President, even though the Judicial Service Commission has the power to discipline judges. This committee's concluding observations in 2003 expressed concern about the power of the legislature to involve itself in the discipline of judges. The state party's report says at paragraph 314 that no judge of the superior courts had ever been impeached. Well, that may have been technically true in October 2012, but very soon thereafter, the Chief Justice of the Supreme Court was impeached under circumstances that achieved worldwide attention. The votes were along party lines and created an appearance of retaliation for the content of constitutional decisions. I say an appearance. Basic elements of fair procedure, including openness and opportunity to confront evidence, were reportedly denied. The decision was made very rapidly, and there were other concerns as well. The Chief Justice was then replaced by a close advisor of the President. The reply to the issues says that the Supreme Court has later held that the procedure used was in accordance with the Constitution. But I have read the Supreme Court's decision on that subject. In fact, I reread it this morning. It seems more accurate to say that the Supreme Court held in its February 2014 decision that it had no jurisdiction to review whether the procedures employed in the impeachment complied with the Constitution. It seems that there is nothing in the Supreme Court's decision on the subject that responds to the widely expressed concern that the impeachment proceedings violated basic notions of procedural fairness and undermined the independence of the judiciary. The court simply held that the national constitution left those matters in the hands of the parliament. May I ask then, what plans does the state party have to restore confidence in the independence of the judiciary after all of these events? Are there any structural changes being planned, or is the state party satisfied with the situation as it stands? I thank the distinguished delegation, and I look forward to the answers.
Thank you very much, Mr. Newman. This is no, there's no subtext here, but just to remind colleagues that we're going to need to leave the delegation time to give their responses as well. So I must ask colleagues to try and be as succinct as possible. Mr. Wasawa, you have the floor.
Thank you, Mr. Chairperson. First, I thank the distinguished delegation for giving responses to our questions in the first round of our dialogue. I have one follow-up question on the first round issues. The armed conflict, which continued for nearly 3 decades, ended in 2009. One would expect that the human rights situation in Sri Lanka have improved since 2003, when it came before the committee last time. However, from a variety of information before us, I'm afraid that we get an impression that the human rights situations actually may have worsened. If that is indeed the case, I wonder why. Mrs. Bimba Jarasinghe, the distinguished member of the delegation, explained that the 18th Amendment of the Constitution have been adopted because the inherent weakness of the 17th Amendment. However, according to information before us, the 18th Amendment appears to be a major stumbling block for the advancement of human rights in Sri Lanka. Generally speaking, human rights can be advanced by a state's own bodies if they function properly. However, in Sri Lanka, because of the 18th Amendment, the institutional framework, which is supposed to promote and protect human rights, seems to be much weaker now than in 2003. Could the distinguished delegation please comment? Now I move to issues in the second round, and I will ask questions on issues numbers 18, 19, and 20. I start with issue number 18. We welcome your plan to raise the minimum age of criminal responsibility. A member of your delegation stated yesterday that it will be raised from the current 8 years to an internationally acceptable level. Could the distinguished delegation explain what the new age will be and when the law will enter into force? Your written reply to issue number 18 was very short. In the list of issues, we had asked about the juvenile justice system and detention of juveniles, but these questions remain unanswered. We would appreciate it if you would give us answers to these questions. And could you explain any available alternative sanctions to the imprisonment of juvenile offenders and their application in practice? Now I turn to issue number 19. I take note that the Minister of Education has banned corporal punishment in schools and that judicial corporal punishment, described in the legislation as whipping, was outlawed in 2005. We commend these measures. Your written replies mention a training program of the National Child Protection Authority's district staff on nonviolence and positive discipline methods. Could the distinguished delegation explain these nonviolence and positive discipline methods? In the list of issues, we asked about corporal punishment in all settings, including in family setting. Nevertheless, your replies were limited to corporal punishment in schools and criminal procedures. Could the distinguished delegation address corporal punishment in family setting? I now turn to the issue of child abuse. In paragraph 95 of the written replies, you listed various actions taken by the National Child Protection Authority to combat child abuse. We welcome these actions. The only information I'd like to ask you is data on child abuse cases in child care institutions. At this point, I'd like to ask a question which was not included in the list of issues, and namely, widespread phenomenon of child labor, including the employment of children in dangerous work-related activities. Could the distinguished delegation explain measures taken to address the problem of child labor? Issue number 20. I thank the distinguished delegation for the answers given to issue number 20, and I have no further questions on issue number 20. Thank you, Mr. Chairperson.
Thank you, Mr. Iwasawa. And the next speaker on my list is Ms. Zybert-4. Ms. Zybert-4, you have the floor, ma'am, both for follow-up questions and the new issues you are going to take up. You have the floor.
Thank you, Mr. Chair. Well, first of all, let me thank the distinguished delegation for its efforts to answer to my questions related to issue number 9. Today I will address issues number 21, 23, and 24. First, I would like to inquire about trafficking in persons, in particular women and children. Trafficking for the purpose of sexual exploitation and forced labor is a persistent issue in the State Party. We recognize that the State Party has taken multiple steps to combat this practice by, for example, the Anti-Trafficking Task Force, which was established in 2010, and the amendment of the Penal Code of 2006, Section 360C. But I was somewhat disappointed to learn from the State Party's replies that only in 2011 the first human trafficking conviction was issued. Could the distinguished delegation please provide us with statistical data showing the number of cases in which persons have been indicted, convicted, and criminally punished for trafficking? What are the measures in place to prevent this practice and to protect and assist victims? What are the remedies in place for victims of trafficking? Turning now to the freedom of expression, assembly, and association, I was pleased to learn from the head of the delegation yesterday that the State Party is fully committed to the protection of human rights defenders and media personnel. I would like to follow up on this by stressing that this commitment also needs to be fulfilled to any person who provides this committee with information. Under no circumstances may human rights defenders be threatened or subjected to reprisals for cooperating with the Human Rights Committee. I would therefore appreciate a statement by the distinguished delegation promising that nobody will be criticized or subjected to reprisals for providing information to the Human Rights Committee. Turning now to the situation in the State Party with respect to freedom of expression more generally, unfortunately we have received prevalent information on intimidation and harassment, including physical attacks, death threats, abductions, administrative detention, and politically motivated charges against journalists and human rights defenders. That there are unresolved cases of violence against journalists was acknowledged by the head of the delegation in his opening remarks. I'm also concerned about information on public defamation campaigns against human rights activists, for example, by state-owned media. The state party claims that there are no restrictions placed on what can be reported by the press. But it is not difficult to recognize that a climate of threats and attacks has a serious impact on the freedom of expression, since it leads to self-censorship. Though the state party points to judicial remedies, which are generally in place, such as writ applications, these are insufficient to protect victims against threats and attacks effectively. There is a need to take vigorous action on any complaint and to actively combat such practices instead of leaving it only to the victims to take action. The replies by the state party indicate that it is pursuing investigations into such cases. I would therefore appreciate to get more information on these efforts and the outcome of these investigations, more concretely. Please refer me to relevant cases in which perpetrators have been convicted for attacks on journalists and human rights defenders. It seems that there is more emphasis on mechanisms to bring complaints and charges against the media. In this context, I would like to know to what extent defamation charges have been brought against journalists. Has Article 120 of the Penal Code, which permits imprisonment for, and I cite, attempts to excite feelings of disaffection to the president or to the government, or attempts to raise discontent or disaffection amongst the people of Sri Lanka, quote, and been used in cases against journalists. Furthermore, I would appreciate if the distinguished delegation could explain whether there are any more plans to have a code of ethics for the media. Turning now to issue number 24, I would like to inquire about freedom of assembly. We have information according to which, in particular in the northern province, assemblies are subjected to oversight, interference, or direct participation by security forces. Assemblies which are deemed critical of the government are allegedly observed by state intelligence services. There are reports about excessive force by police to disperse protesters and threats to protesters, as well as information that memorial events to commemorate the end of the armed conflict have been subjected to restrictions. I would like to receive the comments by the distinguished delegations on these allegations. Finally, with respect to websites, there is information that news websites which have been blocked. I would like to receive more information on the legal grounds for these kinds of restrictions. So far, I've only found a ministerial order of the 5th November 2011. But is there a statutory basis which requires websites that report on local news to be registered? How many registrations have been rejected? On which grounds? Is there an independent judicial body for the oversight of such measures? Is it right that access to some news websites, such as Colombo Telegraphs, Sri Lanka Mirror, and Lanka e-News, is restricted in practice by banning and filtering? For what reason? With respect to remedies, I would appreciate if the distinguished delegation could provide us with some details on a May 2012 ruling by the Supreme Court, which dismissed a case filed against the blocking of a website. Are there other rulings in similar fundamental rights cases? Chairman, this brings me to the end of my question. I thank the distinguished delegation in advance for its answers and hope that our dialogue will prove to be fruitful for the protection of human rights in the future. Thank you.
Thank you very much, Ms. Seibert-Faure. And the next speaker on my list is Mr. Flinterman. You have the floor, Mr. Flinterman.
Thank you, Mr. Chairman. First of all, I would like to thank the delegation for the responses given to my questions yesterday. I have two short follow-up questions. Well, first, I was pleased with the confirmation by the delegation of the relevance of Article 12 of the Sri Lanka Constitution for the protection of LGBT against discrimination. And my question would be, does that mean, also in light of your earlier information, that Article 12 can be used by LGBT people in appropriate circumstances to submit a fundamental rights application to the Supreme Court? And if so, how often has that happened? That's my first question. And yesterday I also raised briefly, and maybe too briefly because I didn't get a reply, I referred briefly to the existence of discriminatory provisions and practices in an area that is very important for women as well. That's the area of land ownership and succession to ownership of land. I referred, among others, to the Land Development Ordinance and to the Kenyan law. And today I would like to refer also to the Jaffna Matrimonial Rights and Inheritance Ordinance, which requires women to obtain the written consent of their husbands or the authority of a court of law to dispose of their immovable property. And I would also highlight the practice, the administrative practice of preferring male heads of households when considering applications for land under the relevant land laws. And my question to the delegation would be to give us some information on the intentions of the state party to remove these discriminatory provisions from the land law regulations in the country. Today, I would like to address issue number 22, which is focusing on a very important issue in the context of Sri Lanka, and that is the issue of IDPs, internally displaced persons. I am grateful to the delegation for the information given both in the report of the delegation and in the paragraphs 101 to 107 of the replies to the list of issues. And it's clear, I think, that a large number of relevant measures have been taken and that a lot has been achieved, and that should be acknowledged, and the government should be commended for that. But it doesn't mean, as also the state party itself acknowledges, that the book on internally displaced persons can be definitively closed. On the basis of information before us, information which is available in general, I have a few questions which I would like to raise and on which I would like to have the information of the distinguished delegation. First question is, some civil society organizations estimate that there are still 90,000 current internally displaced persons and tens of thousands of returned internally displaced persons that remain in need of assistance and protection. And I very much would like the comments of the delegation on these numbers, which differ from the numbers mentioned by the state party in its report. Secondly, my question would be whether it is correct that around 23,000 IDPs cannot return to their homes and lands because their homes and land remains occupied by the state for military or economic purposes. And once again, I would like to have the comments of the delegation. In the report, there's a reference to the draft resettlement policy framework. It's referred to as a draft, and I would be interested whether that draft in the meantime has been adopted and whether that particular draft resettlement policy framework is also addressing prospects for durable solutions. And my fourth question is whether the draft resettlement policy framework addresses the issue of facilitating voluntary choices by internally displaced persons on the basis of accurate and timely information given to such IDPs in order to make their considered and well-informed choices. And once again, I would like to have the information of the state party. And then finally, we have information before us about especially the fate of women who are often harassed in the context of resettlement activities. And I would like to ask the delegation to give us some further, more detailed information about the gender dimensions, both of past and future resettlement policies. Those are my questions for the second round, and I'm looking forward, Mr. Chairman, to the replies of the delegation. Thank you very much.
Thank you, Mr. Flinterman. The next speaker on my list is Mr. Shani. Mr. Shani, you have the floor.
Thank you, Mr. Chair, and I too thank the delegation for its the very valuable information and engagement with the committee. I have one follow-up. I have actually a couple of follow-up questions with relation to one item 11, and then I'll move on to some more issues. I would want first to address the issue of the Trincomalee 5 case that was addressed by Mr. Poulet. Can you please, sir, explain to the committee why did the case drag on for such a long time? Why did it take 7 years to initiate summons? And is the pace of the proceedings in this case consistent with a serious intent to bring to justice the perpetrators? And if so, if now the state is serious about prosecuting the case, why were the 12 policemen released on bail shortly after they've been rearrested in 2013? Given the nature of the charges, and why is the production of an indictment taking on again so much time? And what about the 13th suspect in the case, a senior policeman? Is there an intent to proceed with the case with respect to that individual, or was he exonerated from any charges or any allegations? On the issue of the court of inquiry that Ambassador Ariasina discussed, I would want to remark briefly that I agree with you, sir, that indeed states do have some latitude in employing military commissions to investigate allegations of war crimes under certain circumstances. But the question is, is it plausible for a state to invest a military commission, a military court of inquiry to investigate policies that were allegedly authorized by the highest level of the military, namely the appointing authority and the political echelon to which these military authorities have to respond? For instance, is the court of inquiry capable of examining the specific allegations that were made by General Fonseca regarding the involvement of the Minister of Defense in certain decisions relating to the treatment of the leadership of the LTTE? Now, I appreciate the reference you have made to the COI summary of findings, but surely you must realize that without a detailed discussion of the evidence that was used by the COI to refute allegations that were based on specific testimonies presented to the panel of experts, or specific photographs revealed in the Channel 4 documentaries, it would be very difficult for the state party to meet its burden of showing that it has met its international obligations to effectively and thoroughly investigate serious allegations of human rights violations. And my question is the state party planning to address this concern and to provide the committee and the international community at large with a detailed version of the events with respect to those incidents to which serious allegations have been made, including those incidents with the LLRC itself deemed worthy of further investigation? And will it provide will it back these version of events with specific evidence, such as, for instance, forensic reports or artillery logs, victim testimonies, etc.? Moving on to issue number 25, dealing with General Fonseca and the Underperforming Enterprises Act. The concern which is common to these two issues is whether safeguards against abuse of law exist in these respects in Sri Lanka. Now, the committee is not in a position to assess the evidence against General Fonseca in respect to any official misconduct for which he was tried. The explanation that we are seeking from the government, from the delegation, concerns the appearance of abuse of legal process, which results from the temporal proximity between the multiple legal proceedings that were initiated against the general and his participation in the 2010 elections. Now, the uneasiness with which we observe this temporal element is further exacerbated due to the open-ended nature of some of the offenses with which the general has been charged, such as disobedience to an army order prohibiting political activities and spreading disaffection. The latter offense pertains to an interview in which he allegedly leveled certain charges against the defense minister, something which should be treated as criminal offense only in the rarest of cases, if at all, and also disgraceful conduct. Can the delegation respond to these concerns about the open-ended nature of the charges, and also explain its position on the correspondence between the sentence imposed and the gravity of the crimes for which the general has been charged, and also explain to us whether the presidential pardon, which was granted to the general by the president, is consistent with such gravity of crimes and more generally with the rule of law in Sri Lanka. As for the Underperforming Enterprises and Underutilized Assets Act, can you please explain to the committee whether there are any clearly defined criteria for what constitutes an underperforming enterprise or an underutilized asset? And how does one go about assessing whether such businesses or holdings have an adverse impact on the national economy? We have received certain allegations that the Act has been applied at times in a discriminatory manner against business interests of individuals belonging to or associated with opposition groups. For example, can you explain to the committee why the Sevangala sugar industries, the properties of Daya Gamaje, an opposition politician, have been seized under the Act, and what safeguards have been built into the Act to prevent its abuse, and why was it essential to legislate the Act as an urgent bill? Now, finally, with respect to issue number 26, dealing with the treatment of minorities in Sri Lanka. Now, the replies to the list of issues specifies that certain action has been taken to address reported incidents of disturbances in the recent past. And I'm glad to read that certain action has been taken on, but we would appreciate a higher level of specificity. More specifically, we have before us reports chronicling hundreds of violent attacks, including murderous attacks, which were perpetrated against Christian clergy and Muslims. For instance, the attack of June 2014 in Aluthgama and Beruwala, following a BBS rally. And the question in connection with this specific attack is how does the state delegation respond to allegations that the police did not bar the rally despite the obvious risk of violence, that they did not take the necessary precautions to prevent riots in the aftermath of the rally, and did not intervene aggressively enough to stop the riots after they had broke out. More generally, and this relates to the first observation I made, there are concerns about the low number of prosecutions for ethnic violence and about certain instances in which charges have been brought against the attacked minority members as well as the attackers. And I would want the delegation to respond to these concerns as well as to explain to the committee whether compensations are being generally paid in these sort of incidents. Moving on to other related issues concerning the treatment of minorities, can the delegation please respond to reports that local government bodies have applied pressure on minority religious groups to suspend worship activities if they were not registered with the government, despite there being no legal requirement to do so. Can you also respond to claims that Christian students who refuse to adhere to Buddhist rituals and practices have been punished, forced to pay fines, and pressurized to leave their school by teachers and principals? And finally, on issues relating to the Tamil minority, can you respond to allegations that streets and villages in the Tamil homelands that used to bear Tamil names are being now renamed in Sinhalese? The Tamil places of worship are being destroyed and replaced by Buddhist temples? That thousands of acres of Tamil and Muslim-owned land have been expropriated by the state, often without allegedly a legal basis, and particularly in the war-affected areas such as Ashraf Nagar. And finally, can you respond to allegations that Tamils are not allowed to commemorate May 18, what is in Sri Lanka viewed as the War Victory Day, as a day of remembrance, or as the what they call the Muli Vaikal Day? I thank the delegation for their responses in advance.
Thank you, Mr. Chani. Le prochain orateur sur ma liste, c'est Madame Chanet. Madame Chanet, vous avez la parole.
Ms. Chanet is the next speaker. You have the floor, madam.
Thank you. It's the first time that I'm taking the floor. And I'd like to welcome the delegation from Sri Lanka, a very warm welcome. And I'm very pleased to see that we have this fifth periodic report. Indeed, thank you for all the answers that are contained in the report, particularly as regards to the written questions, the list of issues. And indeed, what we've heard to date from the delegation. Chair, I wanted to focus on one matter, namely the procedure followed, the impeachment procedure against the Chief Justice. This is really fairly rare, I think, that this happens in a country. And if that does happen, it needs to be governed by rules. And I think the committee could recall those rules. The basis for the precautionary obligation resides in the principle of the independence of the judiciary, and this is under Article 14 of our covenant. Everything that has to do with discipline and disciplinary measures which can lead to the impeachment of a judge needs to be governed by the principles in Article 14, which are UN principles regarding the independence of justice. Disciplinary proceedings need to comply with a range of rules and need to respect a pre-established procedure. In other words, the body that needs to determine the sanction handed down, first of all, needs to exist. Preferably, constitutionally, it doesn't have to be or shouldn't be an ad hoc tribunal. It should also be governed by the adversarial procedure, and also there need to be appeals made available. These are UN principles. Now, the causes whereby one can impeach a judge are listed. There are many, indeed, in the Bangalore principles on legal professional ethics. For instance, failure to uphold certain principles may mean that they have to be held accountable and disciplinary proceedings against them. What, however, is not the case is the decision made by the judge. That cannot of itself be a reason if it simply displeases somebody. And there has to be an appeal open, appeal possibilities, as opposed to disciplinary proceedings being taken. So my first question would be, what are the facts, the actual facts, for which this judge has been reproached, and why these disciplinary proceedings were taken against the judge? Secondly, does this procedure actually follow the Constitution? In other words, the body that ruled on this particular body, is it provided for under your Constitution or a law? in which case, how was it made up or composed? The proceedings followed. We've got information according to which the procedure followed failed to respect the adversarial rules, exchange of proof and evidence, amongst others. There seemed to be some failings in that regard. In 2013, the Court of Appeal seized the Supreme Court for an interpretation. An opinion was handed down by the Supreme Court in 2013, namely to say that the procedure followed did not respect fundamental rights. That was the 2013 decision of that court. In 2014, just as Mr. Newman has pointed out, Madam Bandalaike took her appeal to the Supreme Court against the impeachment proceedings. Actually, the ruling is on the internet, and basically there are 3 lines to this. The Supreme Court say that they are not competent to judge an impeachment procedure. The fact that they're saying they're not competent doesn't mean to say that the procedure of itself is regular and that it does comply with international imperatives and requirements, particularly international law rules, and more specifically, the rules in the Covenant. The delegation yesterday, I think, rather reject that argumentation, saying that the Supreme Court had in fact given their imprimatur. But no, they said that they were not competent for this. And when they did hand down a decision, they did express reservations as regards the way these proceedings were held. But we don't yet know the reasons behind this whole procedure. So I do thank in advance the delegation for any answers to that. The Chair, thank you, Madame Chanet.
Mrs. Latescu. Mrs. Latescu, you have the floor.
Thank you to the delegation. Thank you, Chairman. Thank you to the delegation for its detailed explanations. And I would like to keep my questions short, since some of this has already been touched by my colleagues. I'm going to inquire into the questions 23 and 24, which touch on the issues of the freedom of expression, freedom of assembly, and freedom of association. The current humanitarian and human rights breaches in Sri Lanka have been covered by the media, but it has been difficult to get accurate information and analysis because journalists in Sri Lanka, from whom we have received reports, are subjected to pressure and persecution if they try to challenge the government's version of events. We have noted that independent reporting, especially when it comes to political criticism, is almost unmanageable. Disturbingly, Sri Lanka's constitution permits the control of expression when it is considered in the national interest. Documenting the abuses of the last 2 decades, Amnesty International, the Committee to Protect Journalists, and Human Rights Watch have reported serious cases of attacks on journalists, government censorship of publications and independent media, trials and incarceration of those charged for violating harmony, quote unquote, under the national emergency regulations. The local media keeps on operating in an environment of anxiety, being aware that phones and electronic communications are recorded and in consequence became self-restrictive, assuming self-censorship when it approaches sensitive topics of the regime. Those who challenge the government do it at the risk of their lives, while threats and intimidations have been repeatedly reported by journalists and democratic activists. Media channels such as Sirasa TV and the Sunday Leader have been attacked on their sites, and a number of reporters have been seized or violently aggressed. The estimates of Amnesty International approximates that at least 15 have been killed since 2006. In 2009, La Santa Vikramatunja, I apologize for my pronunciation, founding editor of The Leader, was killed in broad daylight in a high-security zone guarded by the army. One journalist cartoonist, Prajit Ekneli Duga, has been missing since January's 2010 presidential election and has been recently reported as hiding in France. Another T.S. Tisainai Gam was condemned in 2008 to 20 years of hard labor for inciting hatred, but was freed after continuous pressure from foreign press. It is important that hidden ever since and chose to remain silent. Across Sri Lanka, NGO workers are treated with distrust. Diplomats and UN workers have encountered severe censorship for expressing any disapproval with official policies, while human rights activists are frequently subjected to intimidations and pressures. We have been informed that since 2008, Sri Lanka's state intelligence has aggregated a list of names of NGO workers, scored with a point system with prominent government critics topping the list, and that furthermore such politics led to the expelling of the lead staff of the non-violent peace force in spite of their obvious success at their designated field stations. Disturbingly, Sri Lanka's constitution permits the control of expression when it is considered in the national interest, documenting the abuses of the last 2 decades. Amnesty International, the Committee to Protect Journalists and Human Rights have reported serious cases of attacks on journalists. Government censorship of publications and independent media, and trials and incarceration of those charged for violating harmony. I think I have already touched on this. No instance of violence against journalists or attacks on media headquarters have been properly investigated today, and to our knowledge, there have been no suits, even for the obvious crimes. In 2010, the Committee to Protect Journalists has ranked Sri Lanka the 4th worst country for press freedom, on the position 162 out of 165 possible. In the same ranking, Afghanistan, Colombia, Russia, Uzbekistan, Libya scored higher. So here come my questions. What will Sri Lanka do in the future to keep its democratic commitment for building a free press and allow the birth of a civil society? Underwriting to my colleagues, Mrs. Zyberfor's question, is Sri Lanka planning to adopt an ethical code for the media? Second, is Sri Lanka planning to finally amend the constitutional emergency article, which allows discretionary restrictions of the freedoms of speech and leaves room to the intimidations of journalists on the pretext of damaging the civic harmony? Third, are there any plans in place to protect Sri Lankan journalists, democratic activists, and media channels in a country that declares itself a democracy but where free speech is still a threat to the speaker's life? This also touches on the 24th question on the list of issues, where the committee is inquiring into the restrictions imposed on the freedom of expression and freedom of peaceful assembly of communities in the north, including the measures through which the state party controls or monitors access to websites containing news and other political content. Next question. Have any investigation been conducted so far in the reported cases of disappearances and murders of journalists? And fifth, has the state of Sri Lanka considered to conclude investigations and or offer any reparations to the families of disappeared or dead journalists? This come, I'm sure, in tune with our query, which has been to provide an update on the outcome of the investigation into the outstanding cases of attacks against human rights defenders and media personnel. Thank you very much, and I hope that the delegation will answer my queries.
Thank you, Mrs. Zatescu. Mr. Sital, I'm sorry, yes, it was down there. Mr. Sital Singh, you have the floor, excuse me.
Thank you, Chairman. May I also welcome the delegation from Sri Lanka, as I'm taking the floor for the first time. I would like to join Professor Newman and Judge Shani on this, on a few remarks on this issue of the independence of the judiciary. It would appear, when we look at question number 2 here, that there is some inconsistency between the stand taken by the Supreme Court in Sri Lanka in the Singarasa case in 2006 and the stand taken by the Supreme Court in the Bandaranaike case in 2014 this year. In the Singarasa case, the Supreme Court is prepared to very jealously guard its prerogative when it comes to the views of the Human Rights Committee, and has pronounced that it was illegal for the executive to sign the optional protocol to the ICCPR. And from that time on, it would appear that the Sri Lankan government has refused to respond to communications presented by Sri Lankan complainants before this committee. And I would urge the delegation to take up this matter and to inform the authorities that the Human Rights Committee does not pronounce judgments, but only gives views on complaints which are forwarded to it. So, on the other hand, in the Bandaranaike case, the Supreme Court is prepared to relinquish its independence vis-à-vis the executive and Parliament by defending the procedure for dismissal of a member of the judiciary by Parliament. And in this case, as we know, it was the Chief Justice who was dismissed. And as Mr. Shane has said, we do not know the precise reasons for which she was dismissed. What matters to us is more the procedure that was followed rather than the merits of the case. And my question on this issue is, when I look at Section 4 of the Constitution of Sri Lanka on the exercise of sovereignty, it very surprisingly says that the judicial power of the people shall be exercised by Parliament through courts and tribunals and institutions which are created. And except for when it comes to privileges and immunities of Parliament and its members. I say that this is surprising because this questions the doctrine of the separation of powers about the independence of the judiciary. How can the judicial power of the people be exercised by Parliament through courts when Parliament itself, consisting of the legislative, should be separate from the judiciary? And I would urge again this question to be reconsidered, because then it puts the judiciary at the mercy of a party in power. If a party in power has got a majority of votes in Parliament, it would mean that that party does control the judiciary. And this would diminish the prestige and reputation of the judiciary, not only in the eyes of the world, but also in the eyes of the people of Sri Lanka, who would not be sure that they would be obtaining justice from their judiciary. I thank you, Chairman.
Thank you, Mr. Sital Singh. I see no other colleagues asking for the floor. I'm going to permit myself a couple of questions. One following up from Mr. Shani's follow-up on issue 9. And I'm very pleased that there is further attempts to inquire, despite the protracted nature of the process, into what happened in respect of the ACF 17 and the Trinco 5. And here I note in parenthesis that the very dignified father of one of the students killed in Trincomalee on that occasion, Dr. Manoharan, is with us today, and I'm very conscious of his presence. The question is, in respect of both of them, the problem of witness testimony when, for very understandable reasons, the witnesses have gone abroad for their own safety. And do I understand from the response that we've received, particularly in relation to the contacts that there have been with the French government in relation to the ACF, but it could be with others as well, that the government has now changed its position and it is prepared to allow testimony to be delivered from overseas by audio-visual means so that it can be examined, but with the location of the individual not being disclosed for the same reasons of concern as led to the flight from the country in the first place. If so, that would be a very positive development. If not, of course, then one can understand why witnesses will still not be forthcoming, crucial witnesses to the resolution of those incidents. The general question is one that the delegation may wish to respond to, perhaps in writing when it's had more time, but I'll ask it now. and that is, have there been any occasions of commissions of inquiry into Sri Lankan commissions of inquiry into serious human rights violations set up by a particular administration in respect of human rights violations committed under the authority of that administration that have actually led to clarification of the fate of the disappeared or prosecutions of persons responsible for illegal abduction, murder, and torture. And with that, the second round of questions is ended, and the delegation again has 15 minutes to concert its replies. I realize, regrettably, we can't go past 1 o'clock. I wish we could, but we can't because we have another delegation this afternoon. So I realize it's not going to be possible for the delegation to answer all our questions orally right now. There are the 48 hours after the meeting closes for the delegation to provide further responses in writing, which of course we will take extremely seriously, just to understand that we understand the pressures, we're under the pressures and we understand the pressures. And with that, I suspend the meeting for 15 minutes.